हेलो दोस्तों, आप लोगों का स्वागत है हमारे चैनल टेक क्लोज में। आज हम लोग बात करेंगे आर्टिकल 19 के बारे में। फर्स्ट ऑफ ऑल हम लोग देखेंगे कि आर्टिकल 90 क्या है। हम लोग डिस्कस कर रहे हैं इस सीरीज में फंडामेंटल राइट्स। लेट्स आर्टिकल 19 ऑफ द इंडियन कॉन्स्टिट्यूशन। आर्टिकल 19 इज टॉक अबाउट प्रोटेक्शन ऑफ सर्टेन राइट्स रिगार्डिंग फ्रीडम ऑफ स्पीच एक्सेट्रा। Okay, so Article 19 of the Constitution of India guarantees six fundamental freedom to every citizen, namely freedom to speech and expression, freedom to assemble peacefully or without arms, freedom to form association, union or cooperative societies, freedom to reside and settle in any part of territory of India, and freedom to practice any profession or carry or any occupation, trade or businesses. So let's see, I explain one by one again. Article 19, clause 1, subclause A is talk about freedom of speech and expression कि आप अपनी बात को कह सकते हैं. You can express your opinion in any form, like you can use social media, you can write the article, you can speak somewhere. You can put your like you have the freedom to speak. Okay, this is the Article 19, clause 1, subclause A. Then second, right to assemble peacefully and without arms. So you can assemble peacefully, like आप लोग इकट्ठा हो सकते हो peacefully, and you can protest against the government or any particular things. So you can protest your and put your demand before the government, or so you can do. This is the fundamental right under Article 19, clause 1, subclause P. फ्रीडम टू असेंबल पीसफुली, कि आप लोग पीसफुली इकट्ठा हो सकते हैं विदाउट आर्म्स. ओके, आर्म्स शुड नॉट बी देयर. देन आर्टिकल 19 clause 1 subclause C is talking about freedom to associate without like association, union and cooperative society. तो आप लोग अपनी एसोसिएशन बना सकते हो, लाइक देयर इज अ एसोसिएशन ऑफ द बार्स, एडवोकेट मिलकर के अपनी बार्स की एसोसिएशन बनाते हैं. एंड यूनियन, लाइक आपने सुना होगा कि मजदूरों की यूनियन है, तो यूनियन लीडर इज देयर. Okay, so and cooperative societies. So this is a fundamental thing, like you can uh, um, form your association, union or cooperative societies. Now next one is under Article 19, clause 1, subclause D, freedom to move freely throughout the territory of India. And आप पूरी इंडिया में कहीं भी घूम सकते हैं विदाउट एनी रिस्ट्रिक्शंस, कि आपको वीजा चाहिए या कुछ चाहिए, नथिंग इज रिक्वायर्ड. You can move throughout the India without any restrictions. Okay, and freedom to practice any profession or carry out any occupation, trade and businesses. So Article 19 subclause D is talking about freedom to practice any profession or carry any occupation, trade and businesses. But there is a reasonable restrictions also over there. Reasonable restrictions means कि जो ये सारे fundamental right आपको Article 19 में मिले हैं, इनके ऊपर एक reasonable restriction लगाई गई है कि आप फ्रीडम ऑफ स्पीच आपको दी गई है. यू कैन स्पीक एनीथिंग, बट यू आर नॉट गोइंग टू स्पीक अगेंस्ट द कंट्री, अगेंस्ट, लाइक यू आर नॉट गोइंग टू गिव एनी हेट स्पीच की पीपल, लाइक वायलेशन हो जाए और झगड़ा हो जाए लोगों के बीच में. सो देयर इज अ रीजनेबल रिस्ट्रिक्शंस, यू कैन अंडरस्टैंड इट. सो दीज सिक्स फंडामेंटल फ्रीडम आर द नेचुरल एंड बेसिक फ्रीडम inherent in the status to a citizen. However, these freedoms are not absolute or controlled, but subject to certain reasonable restriction. It is the article, in this article, the author will take your through the six fundamental freedom provide under Article 19 along with the relevant case laws. So freedom of speech and expression, Article 9, Clause 1, Subclause A, and Article 19, Clause 2. Meaning of freedom of speech and expression. So freedom of speech or expression से आप लोग क्या समझते हैं? What is freedom of speech? So freedom of speech and expression means the right to speak and right to express oneself through any medium, by word or by mouth, by writing, by picture, by sign, or internet, etc. You can use any medium. Every citizen has right to hold an opinion and to be able to express it, including the right to receive and impart information. So हर एक सिटीजन को ये अधिकार है कि वो अपना ओपिनियन एक्सप्रेस कर सकता है, इंक्लूडिंग राइट टू रिसीव द इंफॉर्मेशन, की उसको इंफॉर्मेशन भी रिसीव हो. आर्टिकल लाइक राइट टू रिसीव द इंफॉर्मेशन इज आल्सो द फंडामेंटल राइट इन द आर्टिकल 19. Okay, so the expression freedom of speech and expression has a wide connotation. It include the freedom of the propagation of ideas, their publication and circulation. So जो connotation हम लोग समझ सकते हैं कि आर्टिकल 19 के फ्रीडम ऑफ स्पीच में इज अ वाइड connotation, लाइक इसमें बहुत सारी चीजें आ जाती हैं. सो इट इंक्लूड लाइक आप जो अपना आइडिया है या आप पब्लिकेशन कर सकते हैं, अपना जो इंफॉर्मेशन है उसको सर्कुलेट कर सकते हैं, राइट. सो दिस इज देयर. एंड स्कोप ऑफ फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन. तो स्कोप क्या है फ्रीडम ऑफ स्पीच का? तो फ्रीडम ऑफ स्पीच लाइक फ्रीडम टू प्रेस. अब हम लोग बात करते हैं फ्रीडम टू प्रेस की. तो फ्रीडम टू प्रेस इज perhaps the most important freedom under the right to freedom of speech and expression. Freedom of the press does not find an explicit mention in the constitution. However, it has been indisputably held to be an important aspect of the freedom of speech and expression, and it is implied under Article 19, clause 1, subclause A. Freedom of press means, अब freedom of press का मतलब क्या है? There can be no pre-censorship in the press, कि press के ऊपर pre-censorship नहीं होगी. That is the thing. No pre-stoppage of the publication in newspaper of articles or matter of the public importance. और जो नो प्री स्टॉपेज ऑन द पब्लिकेशन ऑफ न्यूज़पेपर ऑफ द आर्टिकल और मैटर ऑफ द पब्लिक इंपोर्टेंस. अगर पब्लिक इंपोर्टेंस का मैटर है तो उसके ऊपर प्री स्टॉपेज पब्लिकेशन के ऊपर नहीं लगाया जाएगा. न्यूज़पेपर कैन पब्लिश द न्यूज एंड इंफॉर्मेशन विदाउट एनी restrictions, without any without any restrictions, right? And freedom to circulation. So press have the freedom to circulate their information, their news among the people, among the public, for the welfare of the people. Okay, no exclusive tax on the press, etc. और प्रेस के ऊपर कोई exclusive tax नहीं रहेगा because they are press and they are running this newspaper. Because of that, you have to pay that excessive tax. That is not should be there. Okay, however, restriction can be imposed in the interest of the justice, but those restrictions must withstand the test of the article 19 clause 2. अब जो प्रेस के ऊपर restrictions है वो होगी as per the article 19 clause 2. So let's see what it is. So there is a case law I just want to discuss with you all. Bennett, Coleman and Company versus Union of India 1972. So in Bennett, Coleman and Company versus Union of India, the Honorable Court, Supreme Court, held that the freedom of press embodies the right of the people of free speech and expression. It was held that freedom of press is both qualitative and quantitative. Freedom lies both the circulation and in the content. So जो फ्रीडम ऑफ प्रेस है वो दोनों चीजें कैरी करती है. लाइक ये आपकी क्वालिटेटिव भी होनी चाहिए और क्वांटिटेटिव भी होनी चाहिए. सो फ्रीडम ऑफ प्रेस, freedom lies both the circulation and contents. Okay, now we discuss there is another case law. It is very famous case law. Is a Ramesh Thapar versus the state of Madras 1950. In the landmark case of Ramesh Thapar versus the state of Madras 1950, the Supreme Court observed that freedom of speech and of the press lay at the foundation of all the democratic organization, for without free political discussion on no public education, so essential for the proper functioning of the process of proper popular government is possible. The court in this case held that the freedom of circulation is as important as the freedom of publication. So कोर्ट ने कहा कि जो आपकी फ्रीडम ऑफ सर्कुलेशन है और फ्रीडम ऑफ publication both are important. Okay, in this case Ramesh Thapar versus the state of Madras. So let's start. So state of UP versus Raj Narayan 1975. Okay, so right to know and to be obtain information. In the state of UP versus Raj Narayan 1975, the Supreme Court observed that the right to know is derived from the concept of freedom of speech. The court further held that the people of the country have a right to know every public act, everything that is done in a public way, and their public functionaries. It is a basic postulate of the democracy that every citizen must have the right to know about what the government is doing. It is only when the public is aware of the act of the government and transparency and accountability in the government can prevail. Thus, the right to obtain the information and dispensations, it is the important foundation right. In India, we have the Right to Information Act 2005, which provide the right to citizens to ensure access to information under the control of public authorities. So, what it is said in the state of UP versus Rajnaren, इसमें कहा गया कि सुप्रीम कोर्ट ने कहा कि हर एक व्यक्ति को ये जानने का अधिकार है कि हमारी सरकार क्या कर रही है और इट इज नॉट ओनली द पब्लिक इज अवेयर कि गवर्नमेंट का एक्ट कर रही है गवर्नमेंट की को चाहिए कि वो अकाउंटेबिलिटी एंड ट्रांसपेरेंसी एंड अकाउंटेबिलिटी हो गवर्नेंस में एंड जो गवर्नमेंट पब्लिक है वो इंफॉर्मेशन ले सके गवर्नमेंट से सो देयर इज अ राइट टू इंफॉर्मेशन एक्ट 2005 ओके सो केस लो हम लोग देख लेते हैं राइट टू नो द attendance of the candidate at election in the Union of India versus Association for the Democratic Reform 2002. The Honorable Supreme Court held that the voter have a fundamental right to know the antecedent of the candidate contesting election, including his or her criminal past. सो इस केस दो में बोला गया सुप्रीम कोर्ट ने बोला कि वोटर को ये राइट है कि वो जान सके कि जो कैंडिडेट है उसके प्रीवियस में क्या एंटीसीडेंट रहे हैं उसकी क्रिमिनल हिस्ट्री क्या रही है सो ये जानने का वोटर को राइट है एंड राइट टू रिप्लाई इन द LIC वर्सेस प्रोफेसर मनुबाई डी शाह 1992 द सुप्रीम कोर्ट रूल्ड दैट द राइट टू रिप्लाई including the right to get that reply published in the same news media in which something was published against or in relation to a citizen is protected under Article 19 subclause A. So right to reply जो है ये आपको LIC वर्सेस प्रोफेसर मनुभाई डी शाह 1992 में कहा कि दिस इज अ फंडामेंटल राइट कि आपने अगर कोई पब्लिकेशन में कोई इंफॉर्मेशन पब्लिश की है सो द अदर पर्सन आल्सो हैव द राइट टू पब्लिश द सेम इंफॉर्मेशन इन द सेम न्यूज़पेपर लाइक ही कैन पब्लिश हिज रिप्लाई एज वेल सो दूसरा आपका राइट टू बी साइलेंट दिस इज वेरी लाइक लैंडमार्क इज राइट टू स्पीक इंक्लूडिंग द राइट नॉट टू स्पीक और राइट टू रिमेन साइलेंट In the Bijoy Immunal versus State of Kerala 1986, the Supreme Court upheld the right to silence of 3 children who were expelled from the school because they refused to sing the national anthem. So the court held no person can be compelled to sing the national anthem if he has genuinely conscious, if he is like genuinely conscious and object based on his religion belief. Hence, the right to speak and the right to express include the right not to express and to be silent. इस केस में बिजॉय इम्यूनल वर्सेस स्टेट ऑफ केरला में बोला गया जो 3 बच्चे थे लाइक दे आर एक्सपेल्ड फ्रॉम द स्कूल उनको स्कूल से निकाल दिया गया बिकॉज वो लोग नेशनल एंथम नहीं गाते थे और जो उन्होंने इस केस में बोला कि ही हैज अ जेन्युइन like consciousness so वो जनरली उनका कॉन्शियस थे वो और उन्होंने ऑब्जेक्ट किया बिकॉज वो सोचते थे कि उनकी जो रिलीजियस फीलिंग है वो हर्ट होगी सपोज इफ दे आर गोइंग टू सिंग दैट टू सो दे आर रिमेन साइलेंट while like people are sing this national anthem so right and after that there is another case law that is a landmark case right to fly the national flag. In the case of Union of India versus Naveen Jindal in 2004, the Supreme Court held that flying the national flag with respect and dignity is an expression and manifestations of one allegiance and feelings and sentimental of pride for the nation and therefore is a fundamental right protect under Article 19, Clause 1, Subclause A. However, the flying the national anthem cannot be for commercial purpose or otherwise and can be subject to the reasonable restrictions. So इसमें ये भी बोला जो आप नेशनल एंथम अपना जो आप अपना तिरंगा लहरा रहे हैं वो कमर्शियल पर्पस के लिए नहीं लहराएंगे और इसके ऊपर रीजनेबल रिस्ट्रिक्शंस लगाई जा सकती है. दिस इज नॉट द एब्सोल्यूट राइट. But in this case law, Union of India versus Navin Jindal in 2005, Supreme Court held like every person, every citizen have the right to fly the national flag with dignity. Okay, so he can do so. And now रीजनेबल रिस्ट्रिक्शन ऑन द राइट टू फ्री स्पीच एंड एक्सप्रेशन. सो उसके ऊपर क्या क्या रीजनेबल रिस्ट्रिक्शंस लगाई गई ऑनरेबल सुप्रीम कोर्ट के द्वारा. द राइट टू फ्री स्पीच एंड एक्सप्रेशन इज नॉट एन एब्सोल्यूट राइट एंड इज सब्जेक्ट टू द रीजनेबल रिस्ट्रिक्शन as per 19 article 19 clause 2. Restrictions can be imposed upon the freedom of speech and expression in the interest of sovereignty and integrity of the India. You cannot speak anything against the state or against the sovereignty and integrity of the India. The security of the state. You are not speak anything which is like about the security of the state. फ्रेंडली रिलेशन विद द फॉरेन स्टेट. सो आप किसी दूसरे स्टेट के लिए भी ऐसा कुछ एक्सप्रेस नहीं करेंगे जिससे हमारा रिलेशन दूसरे फॉरेन स्टेट के साथ खराब है. पब्लिक ऑर्डर, डिसेंसी एंड और मॉरलिटी. सो यू आर नॉट स्पीक एनीथिंग लाइक विच इज अगेंस्ट एनीबडी, लाइक किसी के खिलाफ जो मॉरली राइट ना हो या कोई डिसेंसी ना हो. You have to speak with the dignity, right? In relation to the contempt of court, or आपको contempt को like you cannot abuse to the court or against, like you can speak against the court. Defamation statement, you cannot defame to anybody. किसी का अपमान नहीं कर सकते, किसी के against किसी को defame नहीं कर सकते. Okay, and incitement of an offense, incitement of an offense, या किसी को इंटिमिडेट नहीं कर सकते ऑफेंस करने के लिए, अबेटमेंट नहीं कर सकते. Okay, so freedom of assembly, article 19 clause 1 subclause B and 19 clause C, like clause 3. The object of holding an assembly or meeting in the propagation of idea and to educate the public. Hence the right to assemble is a necessary corollary of the right to free speech and expression. Article 19 clause 1 subclause B provide the right to assemble peacefully and without arms. So जो आर्टिकल 19 क्लॉज B है वो आपको राइट देता है कि आप पीसफुली बिना हथियार के असेंबल इकट्ठा हो सकते हैं. दिस इंक्लूड द राइट टू होल्ड पब्लिक मीटिंग, हंगर स्ट्राइक एंड राइट टू टेक ओवर procession. However, the assembly must be peaceful and without arms. So जो ये राइट है आर्टिकल 19 क्लॉज 1 सब क्लॉज बी, ये हम लोगों को राइट देता है कि हम लोग पब्लिक मीटिंग कर सकते हैं, हंगर स्ट्राइक कर सकते हैं, भूख हड़ताल कर सकते हैं, एंड राइट टू टेक आउट प्रोसेशन, यात्रा निकाल सकते हैं. हाउएवर द असेंबली मस्ट बी पीसफुल और विदाउट आर्म्स. जो आपकी असेंबली जो लोग इकट्ठे हुए हैं वो विदाउट आर्म्स और शांतिपूर्वक इकट्ठे होने चाहिए. दे आर नॉट डूइंग एनी वॉयलेशन. ओके, सो इट इज pertinent to note that there is no right to hold an assembly on government premises or private property belonging to other. Okay, so ये pertinent है. इसमें केस लो हम लोग उसकी भी बात कर लेते हैं. In हिम्मतलाल वर्सेस पुलिस कमिश्नर बॉम्बे 1972, the Supreme Court struck down a rule that empowered the police commissioner to impose a total ban on all public meeting and processions. It was held that the state could only make regulation in aid of the right of assembly of the citizen and could impose reasonable restriction in the interest of the public order, but no rule could be prescribed prohibiting all meeting or procession altogether. So इस केस में यही बोला गया हिम्मत लाल वर्सेस पुलिस कमिश्नर ऑफ बॉम्बे में कि आप स्टेट कैन मेक द रूल and they can impose the reasonable restriction, but they cannot curtail the fundamental right to be like assemble. If there is a necessity, they can they can come together, they can do the meeting or strike, whatever it is. Okay, but so state can make the rules and put the reasonable restrictions. They can do the meeting without arms, like there is a peace assemble peacefully without arms, but they cannot do these things, like you cannot assemble anymore. Okay, so this is like that. So reasonable restriction on the right to freedom of assembly. According to clause 3 of the article 9, the right of freedom of assembly could be restricted on the following ground: in the interest of the sovereignty and integrity of the India, or in the interest of the public order. So if suppose there is a like, so दो restrictions इसकी impose की जा सकती हैं right to be assembled, कि अगर वो like in the interest of the sovereignty and integrity of the India, and in the interest of the public order. Okay, so maintain the public order, you can put a restriction on it. Freedom to form the association, union, or cooperative societies under Article 19(1) Clause C and 19 Clause 4. So Article 19(1) Clause C provide for the right to form association, union, and cooperative societies. In association, refer to a group of persons who have come together to achieve a certain objective, which may be for the benefit of the members, of the welfare of the general public, or the significant charitable or any other purpose. So आर्टिकल 19(1) क्लॉज सी में बात जो हम लोग करते हैं, हम लोग बात करते हैं एसोसिएशन की, कि वी कैन form the association of union or cooperative societies, okay, and so on. But in the article 19 clause 4, we are put the reasonable restriction altogether, like the right to form association is considered as the lifeblood of a democracy. So आपको जो एक यूनियन बनाने का, एक एसोसिएशन बनाने का जो है, ये डेमोक्रेसी का फंडामेंटल राइट है. एज विदाउट सच एज राइट द पॉलिटिकल पार्टीज कर्टेल टू द फंक्शनिंग ऑफ एन डेमोक्रेसी कैन नॉट बी फॉर्म. और उसके बिना इस राइट को वर्डेल करके आप एक डेमोक्रेसी की फंक्शनलिटी नहीं ला सकते. So the right to form an association and union include the right to form in companies, societies, trade union, partnership firm, and club, etc. The right is not confined to mere the formation of the association, but include its establishment, administration, and functioning as well. So it's right के अंदर only it's not talk about the association or forming right, it's also talk about the establishment and administration and functionality as well. So you can form an association, you can like maintain the functionality of this association and union or cooperative societies as well. Okay, so under article 19(1) clause C, you can form an association, union, or cooperative societies. Now reasonable restriction on the right to form an association. अब उसके ऊपर क्या reasonable restrictions लगती हैं, let's see. According to Article 19 Clause 4, reasonable restriction can be imposed on the right to form association, union, and cooperative societies on the following ground. So let's see what is the ground. In the interest of the sovereignty and integrity of the India, or in the interest of the public order and morality. So in these two grounds, you can you can put the restriction on impounding in right to form an assembly. अगर कोई जो एसोसिएशन है या कोई जो आप यूनियन बनाने जा रहे हैं, अगर वो सपोज it's against the sovereignty and integrity of the India, then you can put the ban on it. And if suppose it's against interest of the public order and morality, then also you can put the ban on it. So there is a reasonable restriction would be there. Okay. So now freedom to movement and reside. Article 19 clause 1 subclause D and Article 19(1) clause E and clause 19(5)D. So Article 19(1) clause D और Article 19 clause 1 clause E में हम लोग बात करते हैं, D में बात करते हैं. So freedom of movement. Article 19(1) clause D is provide the right to move freely throughout the territory of India. It means the right to locomotion, such that right to move as per the one own choice. This right includes the right to use roads and highways. Okay, so under Article 19(1) clause D, anybody can move anywhere in the India. Okay, so there is a case law we are talking about here. Is a Chambara Soy versus Union of India in 2007. Some unscrupulous element had blockaged the road, due to which the prisoner was delayed in taking his aligned son to the hospital, and his son died on arrival at the hospital. The Supreme Court held that right of the petitioner to move freely under Article 19 when clause D has been violated due to the road blockage. The court held that the state is liable to pay the compensation for the death of the petitioner's son due to the inaction on the part of the state authorities in the removing the aforesaid blockage. तो इसमें यही बात की गई है कि आपको जो राइट टू यूज द रोड एंड हाईवे इज द फंडामेंटल राइट ऑफ एन पर्सन अंडर आर्टिकल 19 1 clause B. So in this case, the petitioner था उनका बेटा, like he was suffering from some something, or so he was taken to him into the hospital, and meanwhile the road was blockage. So because of authorities are not take the appropriate action and road was blocked, because of that son has died. So states are liable to pay the compensation to the petitioners. Okay, in this case this happened. This is a case of Chambarana Soy versus Union of India in 2007. So freedom to residence. Article 19 1 clause E is stated that it is the fundamental right to every citizen to reside and settle in any part of territory of India. In the case of UP, Avas Evan Vikas Parishad versus Friends Co-op Housing Societies Limited 1995, it was held at the Supreme Court that right to reside under Article 19 1 clause subclause E include the right to shelter and to be construct house for the that purpose. The reasonable restriction on right to freedom of movement and residence as per 19 clause 5, the right to freedom of the movement and residence could be restricted on the flowing ground in the interest of the general public or for the purpose of the protection of the interest of any scheduled tribe. So if किसी शेड्यूल ट्राइब के इंटरेस्ट को बचाने के लिए देयर इज रीजनेबल रिस्ट्रिक्शंस, लाइक आप जंगल में रह के उनको बोलो कि यहाँ पे जो ट्राइब्स हैं लोगों को हटा देते हैं, हम लोग यहाँ पे रहना स्टार्ट कर देते हैं, so you cannot do so. आप ऐसा नहीं कर सकते. There is a reasonable restriction. State can make the rule for them, those people. Like you cannot stay that area because that area is for the that particular tribe, and in the interest of the general public also, state can make the laws. So that is a reasonable restriction. The state can make the laws under Article 19 clause 5, but I mean you can stay anywhere in India. The right to trade does not include the right to protection from compensation in trade. Thus, loss of income on account of compensation that does not violate the right of trade under Article 19 1 clause D. So आपके Article 19 1 clause D में आपको freedom of profession, like you can practice any profession, occupation, trade and practice, but there is a reasonable restrictions. Like suppose if you are, so what is a reasonable restriction? Let's see. Article 19 clause 6 provide that the fundamental right under Article 19 clause 1 subclause G can be restricted in the following way: by imposing reasonable restriction in the interest of the general public. So वहाँ पे general public के interest को देखते हुए वहाँ पे reasonable restriction लगाए जा सकते हैं. By state monopoly. Subclause 2 of the Article 19 clause 6 enable the state to make law for creating state monopolies either partially or completely in the respect of the trade or business or industries or the services. The right of the citizen to carry on trade is subordinate to the right of the state to create a monopoly in its favor. Okay, and also subclause 1 of the Article 19 clause 6 empower the state to lay down by law the profession or technical qualification necessary for practice any profession or carrying on in occupation, trade or businesses. So that's mean Article 19 clause 6 subclause 1 is talking about कि यहाँ पे एक reasonable restrictions वो लगा सकते हैं, like suppose कि by law the profession or technical qualification necessary for practicing any profession. Like suppose you want to be a doctor, so you should have to be the degree of in like medical degree. You should have to be the bachelor degree in the field of the medical. Okay, after that you can practice such profession like doctor. And suppose if you wish to want to be an advocate, so you should have to be the degree of an like bachelor degree in law. So after that you have to be registered as an advocate and you can practice such profession like you can to be an advocate. Okay, so a state can make the law and put the reasonable restrictions on it. In the Article 19 clause 6 subclause 1, the state make the law and put the reasonable restriction or technical qualification necessary for practicing any profession or carrying any occupation, trade or businesses. Okay, so Conclusion: in the landmark case of the Menka Gandhi versus Union of India 1978, the Supreme Court said that it is possible that the right does not find express mention in any clause of the Article 19, Clause 1, and yet it may be covered by some clause of the state article. It is true that the freedom for the press is one such important fundamental right which, though not expressly mentioned, it is implicit in Article 19, one clause, subclause A. And lastly, in the noteworthy, their earlier Article 19(1) provide for seven fundamental freedoms, and clause F provide for the freedom of hold any acquired property which was deleted by the Constitution 40, 44th Amendment Act 1978. So Article 19 clause F, like there is a right to freedom to hold any and acquire the property which is deleted by the government, like by the amendment, and now this is not in Article 19 anymore. So in 1978 44 amendment deleted that things. So thanks for watching the video. If you like it, please like, comment, share, and subscribe to the channel. Thank you for watching.